Good afternoon. I would like to start by saying that I'm honored to open the works of this table regarding the IBDT Congress, that, in my opinion, is the highest level in academic wise in Brazil, and I also believe in worldwide debates regarding international taxation. I'm very honored to be part of this table and be part of this panel that it's so innovative, likewise IBDT, because most of the congresses we attend, many questions remain without answers. So the questions are placed and end by, due to time constraints, debates they do not end the, and then we end by not making congresses do what they should, which is to present answers. So this stable and innovative format of IBDT Congress is very important because through this possibility of this time, we reflect on the day, and by it we present answers. So I believe in law we only grow through dialectics, and Cooper was a huge advocate of it, and this is what we are doing here. Dialectics of tax law to build answers for polemic questions on international taxation. I would like to welcome all lectures, panelists, moderators participating in this panel with me on the person of Professor Rolim, which I started in tax law. It's been some time, Rolim, right? And I would like to say that I'm very pleased after some years being able to chair this table, and he is also a part. IBDT is strict with time, so I had a short time to do the introduction, and we have many members here who are panelists that will answer questions, which is a summary of what was addressed in the Congress today. So, following our script, I would like to pass the floor to Dr. Roberto Codorniz, who will pose the questions together with Dra. Clara Moreira, the moderators of this panel, and they will conduct the questions in order that panelists can present answers. So enjoy your debate.
Muito
So
obrigado,
thank you very
presidente
much,
Alessandra.
Chairwoman Alessandra.
Primeiramente, gostaria de
First,
agradecer
I
a
would like to thank
oportunidade
the opportunity
os professores
by
Luiz
Professor
Flávio,
Luiz
Luiz
Flávio
Eduardo
e
Schwerer
Luiz
e
Eduardo
Rodrigo Maita, que
Schweire
são
and
os
Rodrigo
coordenadores
Maita,
desse
the
evento.
coordinators of this
E
event,
gostaria
event,
aqui
and I would
de
like
abrir
to
os debates,
open
né?
the
Nós tivemos
debates
hoje
we had today.
painéis muito interessantes,
Very
uma aula magna
interesting panels, a magna
muito
class, which
interessante do
was
professor
very interesting
Milang.
by Professor
E
Milangi.
o primeiro painel
And the
lidou com o tema
first
do Pillar
panel
seguindo
dealt with Pillar
o
2.
painel foi muito semelhante ao
Following,
último
we had the last
anterior, que foi
panel
do
of
Pillar 1.
last day, which
E
was
aqui
Pillar
ficaram
1.
vários
And we have
questionamentos a
many
respeito
questions
da aplicabilidade
regarding
do
the
Pillar 2 no
applicability
Brasil
of
e eu
Pillar 2
gostaria
in
aqui de
Brazil, and
propor
I
uma
would like
questão
to
geral
propose a
a todos os meus
general
colegas
question to
que
my
estão aqui nessa mesa.
peers
Em
in
primeiro
this
lugar, quais
table,
seriam as
which
repercussões
would
para o
be the
Brasil
repercussions
da
for
adoção do Pillar 2?
Brazil
A gente sabe que o Pillar
regarding
2
the adoption of
ele é
Pillar
pautado
2. We know it is
basicamente por
based
uma
on
Income Inclusion Rule, pelo Globo,
incoming
né, pela
inclusion
proposta do Globo,
rule
que
by
esse
Globe
talvez a
proposal.
Income
The
Inclusion Rule, né,
inclusion
seria
rule
uma proposta de
would
um
be
top-up
a
tax ao
proposal
nível
of top-up
da última
tax regarding
controladora
the last
e
controller,
uma
and
UTPR, que é the Tax Payment Rule, que seria
U2PR, which
de
is tax
aplicação
payment
secundária, caso não
rule,
aplicada a
secondary
Income Inclusion Rule, se
applications. If
aplicaria
we do
essa
not
segunda regra como uma
apply the
forma
income
de
inclusion rule, we
assegurar a
would
estabilidade
apply
do
the
sistema. E também
TPR.
de uma
And
Subject to Tax
also a
Rule, que se
subject
aplicaria no âmbito
total
dos
tax
tratados.
rule for
Então,
all treaties.
eu começo fazendo
So
essa
I
primeira
start
pergunta e duas
posing the first
subperguntas
question, and
também para
two
provocar
sub
aqui
questions,
a manifestação dos
food for
meus
thought by
colegas.
my peers,
Seria no
would
sentido
be
de
in the
que
sense
as regras
that the
PBU brasileiras,
TBU
elas não
Brazilian rules,
satisfariam o
would
escopo
they attend the scope
dependendo
and
qual
object
tax, a
with
gente já
top of
teria, no
tax,
final das
would
contas,
we
nas
have
nossas
by the
tão
end our
questionadas normas
question
CFC, se é que nós
CFC
podemos dizer que
rules,
nós temos
as
uma
we
regra
can
CFC
say that
no
we
direito
have a
brasileiro,
CFC rule in Brazilian law?
a previsão, né,
The
o Income Inclusion Rule,
forecastability of
por sua
income
natureza,
inclusion
já
rule by its
contemplado no
nature
direito
already
brasileiro antes
positive
mesmo
in
da
Brazil's
proposta de um
law
Pillar 2
before
da
the
OCDE,
proposal of
Brasil já tendo
Pillar 2
adotado
by
uma posição
OECD.
vanguardista nesse
It
aspecto,
would
vai
be
ser
the
algo super
avant-garde
bonito.
in
E uma
this
outra pergunta
aspect.
seria,
And the other question,
se por um lado
if
nós
in
temos
one
uma
hand
regra
we have
global
a
única, tão
TBU
ampla no
rule,
sentido de
unique
capturar
and
todo
wide
tipo de
to
renda
capture
em
all
toda situação
sort
em
of
toda situação em que há
income
controle
in
direto e
any
indireto,
situation with
faria
indirect
sentido
and direct
que o
control,
Brasil,
would it
ao
make
mesmo
sense
tempo,
that Brazil in the
fizesse
same
uma
time
forte
would do a
defesa, né,
strong
de matching
advocate
credits nos
of
tratados que
matching
celebra
credits in its
e que nesse
treaties
sentido
and in this
apoiasse um
sense
Pillar 2 ou
supporting Pillar
rejeitasse um Pillar
2
2?
or
Como fica a
rejecting it?
coerência no
How
direito
is the
brasileiro dado esse
coherence in
entendimento? Tem
Brazil's
gente que
law
vê um
for
tão
the
rígido e ao mesmo
strict
tempo a
TBU
dezenas de matching
system
credits nos
and the
tratados
advocate of
que
matching
podem ser
credits in
anulados por
treaties
meio
that can be
dessa
annulled
Income
by
Inclusion Rule,
this
como nós já
income
vimos na
inclusion
fala
rule,
principalmente do
as
professor
we
Schweire,
saw according to Professor
né, a
Schweiri's
forte
talk
crítica
this day.
a essa regra
Strong
em relação
criticism to
aos
this rule
benefícios percebidos
regarding
pelos
granted
países.
benefits
Eles
by
podem ser
countries
referidos
that he
aos
was
benefícios
talking
fiscais do
about
direito
tax
interno, mas que aqui também,
benefits of domestic
enfim,
law.
são benefícios que são
Visa
protegidos pelas
benefits
cláusulas matching credits
protected by the matching
dos
credit
tratados.
clauses
E eu
of
gostaria de
treaties. So
apresentar
I'd
essas
like to
questões e
present
chamar
these
agora a
questions
debate,
and call
principalmente
to
meu
debate,
colega Bruno
especially
Fetterman
my
e
dear
Aline,
Bruno
para se
and
manifestar
Aline,
sobre
to
essas questões.
address these questions.
Obrigado, professor
Thank you,
Roberto.
Professor
Eu queria
Roberto.
cumprimentar as
I would like
presenças
to
na mesa, a professora
congratulate the
Alessandra Rolim,
chairwomen of
os
this table,
moderadores, a
Professor
professora Clara Moreira e a
Alessandra,
professora
e pro
Clara Codorniz,
moderator
e os
Clara and
demais colegas
Roberto, and
debatedores.
our
E mais uma
panelists.
vez agradecer
And
também a
thank
toda a
you
audiência do
again,
nosso
the
congresso
audience of
no dia
our
de hoje.
Congress
Bom,
today.
começando pela primeira
Starting
pergunta,
with the
então, que o
first
Roberto nos
question
faz,
that
né, sobre os
Roberto
impactos da
posed
regra,
regarding
das
the
regras do
impacts
Pillar
of
2 no
Pillar
Brasil.
2 rules in
Como
Brazil.
nós tivemos a oportunidade de
As
ver
we
nos
had the
painéis hoje de manhã,
opportunity
né, especialmente
to
nas
see
exposições do
during
professor
what
Bruno
was
da Silva e do professor
presented,
Kina
Professor
Romanovski,
Bruno, Kina
as regras
Romanovsky
do Pillar
panels,
2, elas foram
rules of
concebidas
Pillar
numa
2
perspectiva
were
de
presented
favorecimento
to favor
dos países de
of
residência, né? A
residents
invertência já
countries
seria
by itself
desvantajoso
would
para o
be
Brasil, que é
not advantage for
majoritariamente um
Brazil,
país de
which
ponta.
Brazil is a
Né?
bridge
Esse
country.
viés
This
pró-estado de
bias
residência das
pro
regras do Pillar
state
2
of residence of
fica
Pillar
evidente
2
quando
rules
vemos que
are
a Under-Tax
clear when
Payment
with
Rule,
under
que é uma
tax
regra de um país de
payment
ponta,
rules, which is
ela
a
tem aplicação
bridge
subsidiária em
country. It has
relação
a subsidiary
a
obligation regarding
viés
the
de uma
income
forma bem
inclusion
parecida com
rule,
o que já previa o
similar
plano
to
de
what
ações
was
número 2
foreseen
do
by
BEPS,
Action
quando
Plan
falava lá
2
em
BEPS
Primary Defense
when
Rules
they
nos
say
casos mais
primary
previsíveis, né? Mas lá,
defense
claro,
rules
muito,
for
muito mais
hybrid
restrito, né?
instruments, but it's more
Enquanto,
restricted.
desculpa, a Subject
And
to Tax Rule,
subject to tax
embora seja uma
rule,
regra que se aplica
although it's applied
independentemente da Income
regarding
Inclusion
the
Rule e da
income
Under-Tax Payment
inclusion
Rule,
rule and
a Subject to
the
Tax Rule tem um escopo
subject to
reduzido, né?
inclusion
Porque
rules,
ela
the
só se
scope
aplica a
is
alguns
reduced
pagamentos
because it's
e
only
promove a
applied to
alteração
some
dos tratados,
payments and
provendo a
amend
tributação na
treaties
fonte de
for double
9%. Então,
taxation at
especificamente
source
olhando para a realidade brasileira,
9%.
né,
For
nós já temos
Brazil's
aqui uma série de
reality, we have
tratados que têm
several
previsão de tributação
treaties
na
that has
fonte
the forecast
alíquota
of
maior que
taxation withheld
9%.
at source of
Então, se o
higher than
Brasil passasse a
9%.
adotar uma Subject to Tax
So,
Rule,
if we adapt
ou
it
bem
subject
aplicaria
to
ali aqueles
tax rule or
9%
the aliquot
apenas
of
nos novos
9%
tratados,
only for
ou
new
teria de
treaties,
alterar os
or we had
anteriores, o que
to
seria
change,
prejudicial para o
amend the
Brasil,
previous
né,
one
que,
that
em
would be
princípio, tem
harmful to
tratados que
Brazil. There
autorizam a
are
tributação
treaties
na
that
fonte alíquota maior do que 9%.
at,
Então, o melhor para o caso do
authorize
Brasil, me
withheld at
parece,
source
seria
higher than
sancionar a aplicação
9%
da
tax
Subject to
rate.
Tax
So the
Rule nos
subject to
casos
tax
em que
rule
já hajam tratados
use for treaties
que
that
prevejam
exist
tributação na fonte
foreseeing
maior do que a
taxation
alíquota de
withheld at
9%, né?
source higher than
Quanto a
tax rate
Under-Tax Payment
9%.
Rule,
And now under
além de
tax
violar
payment rule,
possivelmente os
and
artigos 9 e
it might
24 dos
affect
tratados
the 9
registrados em
and
Portugal, como o professor
24
Schwerer mencionou hoje de manhã,
articles as
ele
mentioned by
pode violar
Professor
também
Schwery this
a
morning. It
regra
can
de nação mais
violate
favorecida, né? Que essa é
violate
uma regra
the more
típica dos acordos de
favorable
livre comércio,
nations.
na
That's
verdade,
the
e as
rule of
regras
free
dos
trade
acordos
agreements
OMC
and
têm uma aplicação restrita para a tributação da
OMC.
renda,
They
também é
have a
verdade,
strict for
mas a regra da
taxation
nação
of
mais
income,
favorecida, ela
but that
está
less
presente em alguns
favorable
tratados que é
rules
essa
it's
dupla tributação
present in
propriamente.
some
E no
treaties.
caso brasileiro
And as
support for Brazil agreements with South Korea
Italy and Spain, we have most favorable nation rules. It seems this would not be compatible with under tax payment for Brazil violating the conventional rules. Regarding the second question, I find interesting when Professor Ana Carolina presented this question this morning about the interaction of TBU rules with Pillar 2 rules. OECD did not address specifically Brazil rules, but its model rules of Pillar 2 last year give space for the TBU for Brazil's the model rules they make possible income inclusion rules. Several rules were domestic for a jurisdiction that it's are implemented and administrated consistent with the aim effects of global rules and comments. So perhaps Brazil would be qualified an incoming inclusion rule in spite of its differences, which is a rule that's applied jurisdiction by jurisdiction, and the Brazilian one admits to be consolidated, which would be a difference between both rules. Anyhow, although TBU rules of Brazil are not deemed qualified income inclusion rules, it seems CCL and PG paid by Brazilian rules regarding profits with foreign controlling company will make the difference of in global rules in CCAL and the other taxes will be covered incoming taxes for the calculation of effective tax rates. Both Pillar 2 blueprints and model rules of Pillar 2 include CFC taxes on adjusted covered taxes and model rules talk about it widely. Include adjusted covered taxes levied on um, allocation of profits and those that are fictitiously allocated. So if we do that both taxes are CFC, it seems that our taxes will be included by the wide definition. And finally, regarding max pairing and tax credit, we address this point to hold the attention that OECD once again didn't consider legitimacy of matching credit and tax pairing because when you calculate the tax rate, model rules of Pillar 2 include taxes that were paid on the source state. Therefore, it seems do not admit the inclusion of ficto tax as matching credit and tax pairing rules. So double taxation agreements of Brazil with both clauses. They will consider the taxation at source at a percent at X percent, but for the calculation of tax rates, it will be below X aliquot. So for the assertion of tax on the source state, so Pillar 2 rules ignore or it seems they ignored the benefits of matching credit and taxpaying, and apparently it will be one more incompatibility of Pillar 2 rules for Brazilian system, especially regarding treaties executed of Brazil that include both clauses.
Muito bem, Aline.
Well, thank you,
Obrigada, Roberto.
Aline.
Obrigada, Clara,
Thank you,
Alessandra, a
Roberto,
todos os
Clara,
colegas.
Alessandra, and
Em razão do tempo, vou
here's
cumprimentar
due
todo
to
mundo
time
na
constraints.
pessoa
I
da
will
Clara
congratulate
e
all
da
through the
Alessandra e
person
do
of
Roberto.
Clara, Alessandra,
Prazer
and
estar aqui
Roberto.
presente
It's a
com
pleasure
vocês.
to
Sempre
be
bom
here
voltar para
addressing this
casa,
with you. It's
mesmo que
so good to go
virtualmente.
back here.
Bruno,
Even though
parabéns pela
it's not
moderação
in
hoje da,
person, Bruno,
da mesa
and thank you to be a
o
moderator,
debate do Pillar
chairwoman, and
2
debate
foi
on
um
Pillar
debate
2. It was
excelente
an
e ao
excellent
ponto.
debate, and address important point. What Bruno said, I agree with what he said, and I would like to show and address my point of view and compare it between what I have seen in my practice in Europe and comparing with the view of Brazil in order to bring a bit how the outlooks and are different. But I still have my head on Brazil strong in my mind, and I recall that by 2014 the legislation of TBU and linking with the food for thought by Bruno when TBU legislation was implemented in Brazil. Orlando will recall this. We worked together, and many nights we stayed talking about it, doing charts and thinking how there would be a coherence regarding the taxation of Brazil through TBU rules. One TBU legislation of Brazil uses the legislation on the commercial outcome according to local cap of each country to levy taxes on TBU in Brazil simultaneously when you look the tax side of things. You go look at the gap accounting gap, and many times countries differ on their basis. Now, when you think with what it's available, the model rules of OECD and European Union also disclose their own rules align with OECD, but there are some differences. You can see that it is we go back and Roberto thinks Brazil is a vanguard with TBU legislation because you go back to look to accounting standards in order to set forth the tax basis that simplifying things. What Pillar 2 does is TBU on universal basis for all multinational companies. So what I have seen and how I assess this that maybe TBU rules compared to Pillar 2 they might have an effect to Brazil and what could be the consequences for developing countries and I thinking about Brazil and TBU. I would say immediately what one thinks is Pillar 2 will not affect Brazil because Brazil already levied taxes TBU 34%, quite beyond 15%. So probably it will not have any effect. So I see some issues here. The first one being I think Ana Carolina mentioned this morning. It will be hard for a multinational company of Brazil, present in Brazil, although with entities with assumed profits an effective tax rate below 15%. And when we think about tax incentives that are common in Brazil, ordinary here, and they have their function in a developing economy. If we think about this type of action, which is typical of a developing country, you might yes have problems that you cannot immediately, you don't have an effect immediately on TBU because you're talking Brazil's legislation. But if you see the foreign outlook and other jurisdictions that have investments in Brazil, you might have an effect which is not perhaps immediately expected. And how this is placed in cohesion with tax policy of Brazil. Now we will talk about the last question and what Bruno so well mentioned regarding the consistency. I think there's no consistency regarding Brazil's stand supporting the rules of Pillar 2 as they are now and being suggested and the tax
tax
ah,
policy
de tratados
of treaties
brasileiros,
of
que é uma política
Brazil,
que
which is one
incentiva o tax pairing e o matching
incentivating the
credit. Então, acho que
matching
esses
credit
pontos são
and
os pontos que eu
tax
queria
pairing.
trazer,
Those were the
talvez
points I
não
would
como
like to
respostas, mas como
place, not as
provocações
an answer,
sobre
but food for
como
thought,
essa
how this
compatibilidade entre as regras de
compatibility
TBU
between
e as
TBU
regras
rules
propostas de
and
Pillar 2
those proposed
podem
by
ter
Pillar
um
2
efeito no Brasil que talvez
might
não seja um
affect
efeito que
Brazil, that it's
imediatamente
not one
se pense
immediately is
quando você
thought
está
when
discutindo esse
you are
tipo de
addressing
assunto.
this type of subject.
Queria fazer uma última
One
ponderação,
last thought
no sentido de
in
que,
the sense that
como foi exposto, e
as
há
it was
publicações nesse sentido,
addressed
né?
and
Desde os
publications in
anos
this
90, a
sense,
OCDE
since the
ela vem pouco a
90s,
pouco
OECD
enfraquecendo
is
os matching
getting
credits e o tax pairing
weaker
como
the
medida
tax pairing and matching credits as
política
a
fiscal válida para atração de
valid,
investimentos, né?
effective
Você tem
of
um relatório
tax
da
policy
OCDE
for
que diz
attraction of
que tax pairing é um
investments. We have
consideration e
a
que a OCDE
report of
basicamente
tax-paying
questiona essa atividade
consideration. They
e até
question
um pouco a pouco
these
questionando isso
activities and
e
questioning
posteriormente
this, and
vem
later
defendendo
is
que mecanismos
advocating
se
that
volte para a
mechanisms that
tributação
go
domiciliar
back
de
for
residência
this
como uma
taxation on the
medida
resident
não
states as
para
a measure
fortalecer o
not to
princípio de
strengthen
residência,
the principle of
mas para
residence,
como
but
um
in
objetivo
order with
anti-base
the
erosion, né? E o que a
anti-based
gente vê
erosion. And
que
what we
acontece
see is
justamente
that
nesse
it's
caso,
happening in
nesse
this case, in
cenário
this
do Pillar 2.
scenario, the
Só que o
pillar
Pillar
2.
2,
But
ele não
pillar
olha
2
só
is not
a
only
situação abusiva,
for
não é que
the
nem uma norma CFC,
abusive
ela é calibrada para
CFC
pegar
norm, that it's
literalmente
prepared
esse
for addressing
qualquer
this.
tipo de
There's no doubt
taxa, ela
about what you
acaba
just said.
pegando
So it
todos os
captures
resultados.
all
Nesse sentido,
results in this
ela
sense.
garante
It
que tudo será
guarantees that
tributado
all will
minimamente em
be
15%.
taxed
Então,
minimally at
e, enfim,
15%.
isso tangencia
So
questões de
this
soberania.
we
Então,
have
a
addressing
escola,
now
se eu tenho uma
sovereignty
máquina pública menor,
question.
eu
If
tenho
you
o
have
direito de
a
cobrar
smaller
menos
public
impostos
machine, I can collect, I have the right of
justamente
collecting
quando
less
eu
taxes for those in
dimensiono
my
os
market.
meus
I
investimentos de
dimension my
acordo com o
taxes
tamanho do meu
according to
estado.
the
E
size
é
of my
justamente
state.
esse o grande ponto
And
do
this is
debate
precisely
do
the
Pillar
point
2,
at debate in
que é o
Pillar 2,
aspecto mais
which
questionado
is the
deles,
most
principalmente nos países em
questioned
desenvolvimento
aspect,
e até mesmo
especially
nos
for
emergentes,
developing
onde
countries and
você tem
emerging
essa
countries like
incoerência. Por
Brazil.
um
The lack
lado,
of
a gente tem uma
coherence on one
regra
side,
típica de país
TBU,
desenvolvido,
typical
por
of
outro
developed
lado,
countries, on the other
adotando
side,
os
adopt
tratados
on
marítimos
treaties a
de
policy
países em
typical
desenvolvimento,
of
né? Eles
developing
pegam
countries,
também a
tax
questão de
paying, but
burocracia
also
técnica,
placing
antitrust
technical
entre
services,
outras
Article
questões. Há uma
2, and so forth,
incoerência, digamos assim,
in
da
coherence
nossa
to say
política
regarding
tributária.
our
Eu
tax
posso
Acho,
falar?
policy.
Roberto,
Now I
um
pass
último
the
ponto que a
floor.
gente
And
precisa
last
lembrar
point I would like to address
para se considerar
to
o momento
consider the
também,
momentum
porque o
also,
Brasil
because
fez,
Brazil
está no
is in
processo
the
de,
process of
de join ao OCDE,
joining
então acho que
OECD,
tem uma
so I think
influência
there's an influence
sobre
in
a
my
adoção
idea
dessas
regarding the
regras e o apoio
adoption
a
of
essas
these
regras,
rules and
ainda que
support to
elas não
it,
sejam
although
absolutamente
they are not
consistentes com a
absolute,
política fiscal que vem se
absolutely
desenvolvendo no Brasil
consistent with the
e
developing tax
que os países
policy
já
and
vêm
the
utilizando.
economic scenario of a
Sim,
country
como a
that's
inclusão do Brasil
developing.
no Inclusive
And
Framework
Brazil
do
Inclusion
BEPS,
Framework
que
of
vem
BEPS
participando de várias
Brazil, it's
iniciativas
participating
com a
several
OCDE nos últimos
initiatives
anos.
with OECD during the
Desculpa essa
last years.
palavra
Now I
da
pass the
colega Clara,
floor to my friend
sobre a questão dos
Clara
tributos.
for the next question. My question now we have regarding the second panel of the day, I would like to Valverde to address, but I would like to read many was said regarding transparency of NFT and metaverse transaction and token, and how this transparency would be reached regarding tax point of view and its challenges. Cross-boarding, NFT challenges, how identify bridge states because transactions go through blockchain and the right remuneration. NFT regarding NFT not always represents the word per se, but a copy. So you
Obrigado,
have the
professora
floor.
Clara,
Thank you,
professor
Professor
Roberto, ouvintes,
Clara
agradecer
and
professor Rodrigo Maia,
Professor
professor
Rodrigo
Leite e
Maia,
Fábio também pela
Schweire
organização
e
pelo convite.
Luiz e
Acho que essa
Rodrigo
questão,
Maito.
Clara,
This
era uma questão que já era
question and
difícil no
issue
ambiente que
was
nós só tínhamos
already
a
difficult
NFTs,
when
né?
we just have the
E ela trouxe,
NFTs,
ela foi criada
and
uma complexidade adicional a
it
partir do
has an
momento que a
additional
gente
complexity when
inclui
we include
no ambiente
an environment of negotiations of these NFTs, metaverso, which is an environment where you still don't have much control regarding the transactions that happen over there. So, oh no, the way uh, businesses are carried out or will be carried out, it's at the beginning. So these contracts are binary and there's no clauses. It's the exchange of an asset for the next. So I think the metaverse brought here in an additional complexity, and I think the complexity arises from metaverse transactions. You are not clear the jurisdiction, you don't know where it happened. So under which law that contract was celebrated and set forth? Is it the jurisdiction of the buyer, the seller, where the platform is jurisdiction? So we have a huge indefinition regarding the contract, regarding the transactions where they happen. This is the first challenge. And the second one is all transactions involve most, at least, a transaction where there's an exchange of crypto assets or something similar, which is a Bitcoin or similar currency that's digital, let's say so, in an exchange for a non fungible token, NFTs. So representing the asset that's a digital asset. So something that it's certified the acquisition. The problem is on one hand when you have a payment made by a financial asset like this one, you have no regulating authority or someone in this role controlling the transaction, while you also don't control who's buying, selling the NFT. You don't have the notary here. It's not record, and it's record a huge chain of transactions through blockchain technology, which is also a blockchain of transactions where you're not located in no jurisdiction. So that's the difficulty of connecting the transaction, i.e., the transactions to a certain jurisdiction. So it's difficult to look for connection elements. So my idea for the path that OECD that goes until the 29th, those who like to post their opinion, it's open. But the path is to impose ancillary obligations for those inside these environments, decentralized finance, buy and sell decentralized, like blockchain, and the metaverse path also included. So metaverse, it will be to impose to these entities or transactions in this environment ancillary obligations. So many challenges. We follow here in Brazil the obligation to report with crypto asset transactions. And 188, it works for some things but not others. So you have 888, the exchanges of buy and sell cryptocurrencies. They are obliged to report transactions regarding its clients. But also you have an obligation to report transactions with cryptocurrencies between individuals. And if you join any forum of these transactions, so they don't know because they don't report this. So up to when you can impose this forcibility of this element of making this mandatory for all individuals is a huge difficulty. I think the path is one of technology because today you have different private solutions la
transacionam a partir do
transact
hash
through the hash
de um Bitcoin
of
ou de
a
um NFT.
Bitcoin
Eles conseguem,
NFTs
através da localização
taken
do
through
endereço,
the
identificar quem é o
location of
comprador, quem é o
IP, who
vendedor,
is buying,
e
who is
até, em
selling,
alguns casos,
and
identificar
in
se
some
esses
cases
ativos
identify some of
foi
these
adquirido numa
assets
transação
were
suspeita,
acquired under a
mas que
suspicion transaction.
são
But
tecnologias ainda
these
muito
are
embrionárias.
technologies that
Eu acho que o
they're
caminho
crawling.
não
So
é,
I think
claro,
the
você vai
path you
colocar
will place
obrigatoriedade
the
obrigatoriedade
obligation
de reportar
of reporting
dessas empresas
these
transacionando nesses
companies
ambientes, tem que reportar
transaction
isso
in
em
these
obrigações
environments to
acessórias,
report
mas
these
há
and
também
ancillary
um investimento
obligations,
dos
but
Estados
I
muito
think there are
forte em
strong
tecnologia
investments
para
in
buscar
US in
enxertos
tech to
sustentáveis
look for
de
tax revenues
fontes ou
and
residentes
sources of
que
residents that
transacionam no nosso país.
transact
Então, eu
in
acho
their
que esse é um
country.
caminho
So I
bastante
think this is a path which is
que eu acho que é o futuro,
I deem as the
um caminho
future.
de mais tecnologia.
More
Eu acho que
technology.
respondendo
So,
também a questão
answering
das operações
also
argumentos, essa é
regard
uma
arm's
grande
length
dificuldade que
transactions.
existe
It's
em
a
operações
huge
com NFT.
difficulty
Por
we
quê?
have these transactions
Porque
with
é
NFTs
até uma dificuldade
because
que
it's
os
difficult because
próprios
the own
especialistas em propriedade
experts
intelectual
in
têm dificuldade de
intellectual
identificar,
property
que
they
é
have a
quando você
difficulty
compra
to
um NFT, quais
identify
são os
when you
direitos
buy an NFT
associados
what are the
àquela
rights
NFT.
linked to this
Eu,
NFT.
o Neymar
You,
comprou o
Neymar,
Valday, lá, o macaco
bought
que você está direito hoje
the monkey that
pela
Tatiana
manhã.
showed this
Qual o
morning.
direito que ele tem
What's the right he
daquele
has when
NFT?
he
Ele não
buy that
pode
NFT? Can
reproduzir
Neymar
aquilo para criar
replicate that to create
produtos ou coisas.
products or
Geralmente
something
não é
like this?
isso.
Normally, it's not
Geralmente
that.
você tem um direito
Normally, you have a right
os especialistas
that
Em IP
experts
chamam
in
de bragging
IP
rights, ou seja, é o
it's
direito de
called
você
the
se gabar
bragging
de que você tem
rights
aquele
that
item,
you
de você,
have
o
that.
detentor
So I
único daquele
hope I'm
digital.
the only
Ou seja,
holder of this asset.
o
So
JPEG
JPEG, JPEG
do
of
macaco
the monkey
Moreira, né?
Moreira.
O
So
direito, no final das
it's a
contas,
right
do
by
Neymar. Mas
the end belongs to Neymar.
talvez
But
a utilização
the use of
desse ativo,
this
como
asset,
você a
how
venda desse
do
ativo ou a cobrança de
the
royalties em
sale
relação a esse
or
ativo,
charging royalties on
como ela
the
deveria
asset, how should
ser
it be
calculada, porque
calculated?
não é a obra em
Because it's
si.
not
Já
the
aconteceu
work
com
per
uma obra
se.
recente, que
And
foi a
recently,
obra do
something
Beatles, que
similar the
a professora
people,
Tatiana também comentou,
Professora Tatiana also mentioned.
o artista ele
The
vendeu o
artist
NFT,
sold the
mas ele
NFT,
se resguardou,
but
ele
he
ressalvou o direito de
except
vender o
for
mesmo
the
NFT para
right
outra
of
pessoa.
selling the
Ou
same
seja,
NFT for the
não é,
person. He
não é
only the artist can do it.
um
So
direito único
it's
e
not
exclusivo
exclusive,
que é
unique
dado
right
ao
that
comprador
it's
desse
given
NFT.
to the buyer of
O direito da obra
NFT. The
continua com
right
ele.
on the work remains with the author.
Essa
So the
desassociação
association
entre
that
a
we see
obra
between the work
e a NFT,
and
ela não é muito
NFT,
clara.
it's
Então, eu
not
acho que
that
existem muitas
clear.
dificuldades
So
para
I
esse
think there are
projeto.
many difficulties here.
Se você tem uma
If you have
NFT,
an
você cobra
NFT
um
and
royalties
you
relacionado
charge
àquela
a
NFT,
royalty
o quanto
on
realmente
it,
vale
how
aquele
much
royalties?
is
Quanto que
worth
vale
that royalty? Is it
o que
what
uma expectativa de
an
remuneração
expectation of
que o adquirente
remuneration
tem?
that
Tem
the
todo detalhe
buyer
nessa obra.
has?
Então, acho que
Oh,
existem
so there are
diversas
several
dificuldades aí na
difficulties
atribuição
in
de
the
remuneração
attribution
a
of
esses direitos que
remuneration to
devem
these
deverão ser
rights
mais
that
exploradas
should be
tanto pela OCDE quanto
explored
pelos países.
more by OECD and the countries.
Perfeito.
Perfect.
Passando à
Now, the
terceira
third
questão, remete
question
ao painel número 3.
regarding
Nós
panel
tivemos
3
referente à
that we
troca de
had
informações
regarding
entre
exchange of
a professora
information,
Isabel,
Professor
professora
Isabel,
Ávila, professora Clara,
Avila,
que está aqui
Clara.
conosco
These
nesse
professors are
painel.
here with
E
us
uma
during
questão
that
que eu
panel.
acho que
And a
ficou,
question that
e realmente é
was
uma questão
posed and
controvertida,
it's
é como
controversial.
assegurar
How
os
to
direitos dos
ensure
cidadãos
rights
em
of
troca de informações.
taxpayers
E aqui eu
regarding
trago como
exchange
elemento
of
só para
information? And
problematizar essa questão,
I
acho
would
que não
like to
apenas a
pose here
troca de
not
informações
only
em modalidade
exchange of
pacífica se
information
aplica o
as
chamado
requested,
critério da
that the
preventiva relevância,
criteria of the
que são aí as
foreseeable
chamadas
relevance
expedições de
that
pesca, né?
fishing
Tem que ter uma
expedition that have
supervisão
to have
junto
a
com um objeto determinado para que
supervision with
possa
a
requerer
subject matter
informações sobre aquela
that's
situação em concreto.
established to
Mas eu creio
require the
que hoje em dia
information,
o
but
mecanismo
today I
é
have a
principalmente
strong
o
movement
pós-BEPS,
regarding
né?
post
Em
BEPS
torno da troca
regarding the
automática de
automatic
informações e,
exchange of
sobretudo, da troca
information and
espontânea
especially
de
the
informações
spontaneous
referentes a APAs, né?
exchange of
Asset
information
Purchase
regarding
Arrangements,
APAs
e
and also APRs, advanced tax rulings, which are celebrated bilaterally or unilaterally by tax authorities of countries. Given the dynamics of information exchange currently, added information of several taxpayers that are not applied to the criteria for civil relevance, the intense exchange of information is strong. How to guarantee the right of taxpayers? Is it possible that they, as Professor Clara and Professor Avila said, to know and express themselves and even question the exchange of information in this context? And now, food for thought. If not this type of protection, which type of protection would be adequate for the automatic and spontaneous information exchange? Can we talk about taxpayers' effective rights protection? And I invite for this debate Professors João Rolim and Rodrigo. Good evening, Professor Rolim. Feel free to start. Well, Rodrigo, take the floor. Good evening. I welcome Professor Alessandra, Clara, Roberto, and further members of our table. I'm pleased to share the screen with Professor Rolim. I was his student and I remember so fondly the classes he delivered regarding the protection of data and the controversy regarding protection of individual rights of taxpayers. If we get the source of this big concern regarding tax transparency, evasion, financial crimes, and data sharing idea, on one hand, we are searching for not only to increase collection, but the fair taxation of those with high income and which might be evading taxation on their domicile or residence. The idea of having these instruments, OECD and further countries, to embrace this sort of measure was clearly searching for to end by main targets of this scenario would be tax confidentiality, bank partnership confidentiality, and the idea of increasing collection has a side of protection of human rights that was something that was addressed during the implementation not only here in Europe but when Global Forum incentivate that the report was the standard of automatic information sharing. It's interesting to think that this idea of protection of human rights, the idea of trying to make the fair collection to increase revenues, and we in fact would address this sort of resource to sustain the state to pay the necessary expenses and for those individuals that need more and depend on public services. And this developed throughout the years, and a lot was debated regarding the effectiveness of information sharing, automatic sharing, and by request. But OECD advocates today that 154 countries in this mesh of information exchange, and up to recently, we have more than 5 trillion euros of assets located, more than 500 billion American dollars of resources of these countries that are financial centers, the traditional ones, in fact, with the true reduction of 36% of this sort of resources circulating within the traditional centers, Liechtenstein, Luxembourg, and Switzerland. So, an idea of figures, Brazil has at least 920,000 accounts of individuals with assets abroad that were shared through the CRS. And just doing a parallel with CARF would be the CRS for the crypto assets. Do you think, in fact, this would bring information in the interest of tax supervision? So, in fact, if we get this idea that the information arrives and comes to the tax authority of any country, if the taxpayer that would be irregular and feels threatened, wouldn't this individual look to the regulation of this asset and searching for being effective the public interest regarding collection? This is a point that we are talking about human rights. Now, when we get the other side of taxpayers that also ends by disclosing information regarding their privacy, data protection rights, and also regarding the possibility of the taxpayer opposing this sort of sharing. Perhaps they might not even know it was shared, the data. So, which data was shared? So, they don't have the possibility to oppose the sharing and the automatic sharing. Imagine this happening with cryptocurrency. If this happens, in fact, taxpayers don't cannot express if the data is right or not. If exchange had the true care of showing that the exit would be Y or X. So, in fact, the structure thought by CRS, mirrored by CARF, could guide a methodology for taxpayer access to the data of his or her interest. This could be a line AGPR and D in the sense of aligning the idea of translating clearly in something bilateral. So, if I give you if I'm transparent on my side, I can demand this from other states also, and the state will give you access to this piece of information in a safe basis. Would be the true son of CRS and CAR will have possibly its same base. You have open access to taxpayers, and he would oppose to a wrong data and showing that this information that it might be relevant to supervision in fact is coherent with the data that would be on my bank balance by the end of the year. As an example, Professor Rolim, I don't know if this sort of debate is aligned with your thought about addressing with us here today. Yes, certainly. It was subject matter of one of the classes, of the master classes, and Rodrigo participated. And I would like to thank the invitation to be part of this panel chaired by Professor Dr. Alessandra. We know each other for many years, and its progress not only in the academia but the contribution to Brazil's tax law and international tax law. And I welcome in the person of Professor Alessandra all those here in this panel. As Rodrigo mentioned, well, the I see a problem of rights of taxpayers not to be violated in the phase which we call litigation phase. The pre-litigation phase, where we have the exchange of information spontaneously or automatic, and it happens in different countries. At first, no, but case by case. If in the spontaneous exchange of information or by request you use an evidence, a witness evidence, or a document, that the taxpayer would have the right to present a counter evidence or in witness and so forth. But at first, in the pre-litigation, no, and it would be in line with our constitution. The STF decided, ruled about this, the Inland Revenue, that the possibility without the authorization of having access of the right of bank confidentiality, which is a basic right. And there's a decision, a ruling by the European Court. It's for Europe, but this making the distinction in the pre-litigation phase, there's no violation of basic rights of taxpayers, but states, by the way exercise sovereignty, and also in this part pre-litigation phase. With this, what are the remarks without being adamant in either sense, but in this case is the principle how I view this issue, and also as mentioned by Roberto at the beginning, APAs, tax ruling, that it's involved also with rights of information, confidentiality, and also for the effect of competitions. Let's say a company accessing the information of tax ruling. But on the other hand, the right for transparency and also equal protection by the law. So equality. So these are pieces of information regarding tax ruling or APA in terms of guidelines to say it should, according to my point of view, be revealed, but not pieces of information that are more sensitive regarding protection of trade rights and practices of a company, technology use, and so forth. Well, now I pass the floor to Roberto or Clara. Thank you very much for your explanation. And this is a debate which is quite difficult currently because today we have, in terms of treaty, they don't ensure the minimum protection of taxpayers' rights. So it guarantees the right of a state to refuse information presented if there's disclosure of industrial and commercial information or sensitive information regarding the model, according to the model convention of OECD, and the also what we call the requiring state the treatment of equal protection by the law but the internal source. But today you do not have a letter of rights for taxpayers, of standards of protection for taxpayers' rights, especially regarding the type of information, which is the most sensitive issue regarding today. If you think about the number of hackers attacks and the numbers of disclosures that were due by employees that are not thinking right, and oh, this is a very complex with malicious employees and so forth. Now I pass the floor to Professor Clara. Aline will be very brief. Aline, I would like just in this topic regarding exchange of information, 3 points I would like to address regarding the practical side, as I see a trend that should be taken into account every time we are addressing the subject. In Europe today, when you do an application for a tax ruling, you necessarily in the application you must identify if there's cross-border transaction with more than one country, advancing for the excise that the excise might come to exchange that information. Another point I would like to present regarding practical side legislation of mandatory disclosure rules, which are information of aggressive planning that today in Europe you must report them and can be within Europe they are automatically exchanged, but if there's a third country with a convention allowing this exchange, this is also part of the information exchange. And third, the CBCR report publication, there's a guideline in the European Union that will be implemented in 2023 that within, according to some standards, country by country reports, the legislation country by country reports will be published and all will have access to the space of information. Some exemptions exist regarding exemption that João Dácio mentioned regarding confidentiality and commercial points, but I see a trend and the balance between the right to confidentiality and the participation of taxpayers and transparency that will support the information exchange. It's a difficult tax and very sensitive balance. So I'd like to show the example because it seems to be a practical trend within the international law. Thank you, Clara.
Obrigada, Aline.
Thank you,
Agora a
Aline.
explicação
Now,
em relação à quarta
regarding the
questão
fourth
referente
question,
à aula magna dada pelo
aula
professor Rolim,
magna
certamente,
delivered,
muito embora seja
although
considerado um elemento
it is
teórico,
deemed
o
as
fato é que a
theory the
Constituição
fact that
argumenta
the
que o desenvolvimento
constitution and
da
development
interpretação do
of
texto
the
defendido pelo constituinte se tem um
construction,
arcabouço teórico considerável
there's
que
a
pode ser
theory
analisado,
framework
obviamente,
that can
alguns
be
questionados.
analyzed.
E a
At
quarta questão
least
nada mais é
question.
do que
The fourth
perguntar
question
se os
is
tratados
asking
editados
if
pela
the
Constituição devem ser
treaties
sempre
to
interpretados
avoid
rigorosamente
B
ou se
double
devem dar
taxation
alguns
and
decretos.
there's a rule
E aí
regarding how literal it is and the
eu
counterpoint
queria
addressed
convidar
by
o
the
professor Paulo
professor
Vitor para fazer as
Paulo
nossas
Vitor.
considerações.
Could you address this and show us your
Gente,
point of
boa
view
noite a
on this?
todos.
Good
Queria
evening. I
agradecer
would like to
o
thank
convite
the invitation
na pessoa do
in the person of
Rodrigo Maito,
Dr.
dos
Rodrigo
professores Luiz
Maito,
Flávio, Neto
Luiz
e
Flávio
Schwerin, e dizer
Neto,
que eu estou muito
and
feliz aqui de
Schwerin.
dividir
I'm
essa mesa
so
com
pleased to be
vocês,
part of
Roberto,
this
Clara,
table with
Alessandra,
Roberto, Clara,
Rolim,
Alessandra,
Bruno,
Rolim,
Erlan,
Bruno,
Rodrigo,
Erlando,
Fábio e
Rodrigo,
Aline.
and Fábio and
Esqueci só
Aline.
de ligar aqui meu
I would
alarme para
like
defesa
just
de
to
que eu não vou
switch
falar
on
muito
my
acima dos 5
alarm so
minutos
I don't
combinados.
go beyond the
Eu
given
queria
time. I would like
fazer algumas
to
provocações em relação a
place
isso,
some food for
porque
thought
assim,
regarding this.
para interpretar teleologicamente tratados,
So, how to
eu já vou adiantar de cara a minha
in
posição.
theology construe
Para mim,
treaties?
a não ser que se
So,
negue vigência por
although
violação de direitos
you
fundamentais, ou
deny
que se negue validade
basic
constitucional,
rights,
os limites
constitutional
textuais são
effectiveness, the
intransponíveis.
contextual
Tá? Então,
limits
ou viola a
cannot
Constituição, ou
be
aquele texto é intransponível.
unsurmountable. It is not
Ah,
unsurmountable.
sobre
So,
teleologia,
regarding the
gente, eu acho
theology,
que interpretação
I think
teleológica
the
lança um
this
desafio tão
way of
difícil para a gente
construing
em
it's
matéria
such a
de direito
challenge
doméstico,
regarding
dirá em relação a
domestic law.
tratados.
And imagine
E por que eu estou
regarding
dizendo isso?
treaties. Why am I saying this?
Alguns aqui têm
Some
bastante proximidade
here
comigo
they
na
are
cadeia
very
e
close
sabem
to
mais ou
me
menos
and they know
o que eu
what
penso
I
sobre,
think
não só
about
sobre isonomia, mas
not
principalmente com
only
relação à isonomia
regarding equal
e
protection by
classificação
the
de normas
law
tributárias,
and the
porque
classification of
isso
any
inclusive
tax
é teleologia
rules.
pura.
this is pure theology. The first question one should do is, what's the telos of the treaty? It's so questionable the assumption of regarding the telos of a treaty. If we base on it that it's so questionable, this is something dangerous regarding my point of view, or at least subject to criticism or question can be posed. I'm not saying that we should not construe in this line, but we must take into account. But it's just one argument, and if the law, the right, the exercise of practical, as Joseph has says, to construe a concrete case brings several reasons towards one or other reason. So I know I don't want to give that weight to theology as many authors do. So if we think about the theology of treaties and domestic law, my impression is that we are under a dogma, that perhaps since Savigny, or perhaps by ignorance, it can be before Savigny, and the objective of law and also a treaty, it comes to us through traditions, and I'm not being pejorative here, but also a problem of authority. It is repeated by decades because the function of this rule is this, the function of this tax is that, and it's repeated onwards, and we use it because we heard for a long time. But if we think deeply, because the reasons are more repeated because of authority, so people are tired of this example regarding the taxation by consumption classified by all Germans in the world, but tax between brackets as telos tax purpose. What I found during my PhD, minutes by the German parliament say we must approve this tax because we need the revenues, one cannot do without it. So, how do I construe in theology this? In treaties, it's not that different because if we look the literature more traditional and widely dominant of double taxation treaties, we will find, I will quote just the authority, what we will find the confirmation that treaties function. Um, these are my own words. And extra tax, extra fix to remove hurdles or regarding the flow of capitals. So this is the classic function to treaties. Avoiding double taxation is done to give neutrality to the flow of capitals or international trade. And this is repeated throughout decades. And I ask, why do we should read like this? Because it's the genesis of treaties. When we see the experts during the League of Nations, Blumenziel, and so Temple, we will find they will start the report talking about the capacity of taxes and tax fairness. So why do we have to remove the function of treaties being necessarily this one of fostering capital flow? Because this is said, it was thought, and this has been happening for 50 years, but in the 20s they said differently. So why ignoring this? So why should I ignore the order in constitution? Because it's a priority of these orders. They show the legal order and framework. When I don't find justification extra fiscal for certain differentiation by a treaty regarding brackets the myth of justification, which is extra fiscal, must go back to fiscal fairness because they say that taxpayers should be differentiated according to their capacity of paying taxes because I don't know, it's so difficult to surmount this. So in many matters of treaties I could quote some examples that it seems that it's fully applicable. So I'm a bit beyond my time. I would like to talk a bit about the consistency of Brazil's treaty policy and transfer pricing, but my time is due. I'm sorry. Thank you very much. I would like to do a brief comment. Fábio asked to do a brief comment. Thank you, Professor Clara. Due to the time, I will just reiterate the thanks and welcome without repeating what my peers have mentioned. And I agree fully with what Paulo just said. But I have another question, perhaps common in when you construe a treaty, which is the trend to use OECD comment to shed light on the intention of the contracting parties. And it's very common. In spite of this, in a recent case, the Canadian Supreme Court ruled that it would not be reasonable to apply a comment of OECD, sort of updated. I think it was from 017 for a treaty celebrated during the 80s or 90s. So it says a bit regarding theology and not using the development of interpretation to go back to interpret intentions not necessarily present at the interpretation of treaties, and also the Vienna Principles giving the interpretation of the terms according the language that was used during the execution of these treaties. That's what I would like to mention regarding this issue. Thank you, Flávio. Now going to, let's see, regarding this subject we just addressed, it's highly intriguing and it's important regarding the context of BEPS Action Plan 6, not only regarding the adoption of the benefits clause LOB model that sets forth the clause, but fostered the change of the title of the treaty, which the whereas, so it was a double taxation treaty, it became one earmarked to avoid double taxation and avoid tax evasion. So its purpose would be single tax. So this would be just food for thought. Does this has an effect of declaration or is it innovative? So now I pass the floor to the fifth and last question regarding the last panel regarding ESG, Environmental Social Governance Clause, that was moderated by Fábio Gaspar and led to important questions. And I would like to pose a question in a broader way. What's the relation to ESG taxes with international taxation? So I would like to know what's the outlook of Fábio regarding this and also regarding the other questions addressed. I will start with Fábio and then Professor João Rolim. Well, Roberto, the relation is total. If we get a bit what we addressed during this panel, I say that what we saw regarding the tax responsibility institutional wise, it started within the context of BEPS. So if we look, tax accountability institutional, while a soft law and several principles, depending on the organization you're looking, one B team or any listener, B team taxes in Google, you identify 37 principles regarding it. If we get the 37 principles used by BT and compare it, most of it, a huge amount, with BEPS actions, all are a reflex, but it's the soft law side of it and development of these relations. With this, I mean that BEPS, born as soft law with recommendations, it started to be implemented in different jurisdictions, not in all and not in the same way. And with this, we have a mismatch of legislations opening several possibilities or different interpretation. How the taxpayers can behave in this sense? Go to the moment pre-BEPS and look all the loops and try to use it, or they can comply to several principles that grasp the core point of these proposals and actions by BEPS and decide willingly in agreement with all this in all jurisdictions, not only those that where it is important. I could talk more about, but I will quote two examples due to time constraint. Action 13, it was born as a soft law. I think is one of those that was adopted fastly regarding domestic legislation worldwide. Soft law became hard law, and I mentioned this during our panel. There's a trend of soft law becoming hard law. Second, we saw companies looking this obligation to report their files country by country, the excise, to relate better to community, employees, and consumers, and willingly publish to all its files, tax filings to all. Anyone who they open their books. So we see a momentum of soft law principles guiding behavior in international taxation. And as Aline just mentioned, December 2021, in the European Union adopted a guideline to approve this is soft law, I think, between 2018 and 2021, transforming soft law into hard law. So UN, European Union, let's say companies with branches so forth, except some cases, they will publish their information country by country. So international tax law to company. Another action, Clara, Roberto, if I'm talking too much, please interrupt me. Another action I find relevant, connected, according to my opinion, regarding international taxation and ESG tax or tax liability institutional wise, the name you want to give it is Action 5, which in fact borrowed the report of 98 OECD, harmful tax competition, and reviewed under the eye of substance. Given certain requirements, multinational companies could operate in jurisdiction of low taxation if there was substance. In 018 or 19, I'm not sure, the Action 5 was reviewed to come closer to the substance of what was placed, revamped in 98, and this became several different legislations, especially in the Caribbean islands, that became known as Economic Substance Acts. Again, something that started as soft law OECD became standard in several countries, not all, due to European Union pressure, and became soft law again when company decided to look at it. In spite, I'm not obliged to act according to this, I will do it. So this is a clear connection according to my point of view, and the trend that it seems very present that soft law becomes hard law.
João, por favor.
I agree fully with your remarks, but just adding that another aspect of dealing with problems with the ESG International taxation or double taxation or multilateral convention, the principle, it's difficult, but I also, it seems clear the relation, not only by the source since 2015 with United Nations stating sustainable development and recognizing taxation as the mean, if not essential, necessary for reaching the purposes of ESG. So here we have an essential relation. On the other hand, I also see this relation quite close between ESG, environmental taxation, in the international scenario, both for international trade, uh, including international fundamental rights. So we are not talking only about Europe, human rights, environment, so forth being recognized, but the Inter-American Human Rights Court, and Brazil is a member, recognize the right of life and environment. And the relation comes from the need of taxes being used through incentives or taxation to protect the environment and guarantee sustainable development. And also within the World Trade Organization, international law, it might not be tax stricto sensu international law, but it is entwined. So it allows taxation apparently which is discriminatory based in justifying the environment protection affecting international trade and the right of international trade through tax measures. So also this entwine international entwine, it's very interesting and not to be stuck to the international tax law just dealing with the tax per se without taking into account other areas of law which is human rights and so forth. With this I wrap up. I think we still have some minutes left. Thank you very much, Professor. Now, with this, in fact, we are closing our table of questions. We just concluded, but I would like to thank IBDT for the organization of this event and the member of this table, and I pass the floor to the chairwoman for the final remarks. Well, I would like to thank, on behalf of IBDT, your presence here contributing with the debates regarding international taxation. So I am the person now at this moment closing this debate, and what I saw in all panels of this Congress and here during these issues and questions regarding international taxation, they represent a huge challenge for the world and countries today on an overall. Well, let's think that we have addressed here a world where we have the metaverso with assets totally disconnected with the territory of a country. So metaverso, it's something per se which is fully unthinkable, especially regarding the taxation of it. In our panel, we talked about the taxation of cryptocurrencies in an environment fully deregulated, and we talked about the imposition of ancillary obligations within this context. And we don't even know in which country this is happening. Simultaneously, we must recognize that countries need revenues. The world is more and more poor, and more we depend on public services and public income. And here was also said that revenues are indispensable. So this places how much this represents in terms of challenges, and how simultaneously that a world is and it's not a world. This recalls me a research I carried out in Bologna 2019 addressing if was had a supranational tax law conducted by OECD. And it's clear in my point of view with this debate that we need a supranational tax order because domestic taxation does not supply solution for problems like taxation on metaverse and crypto assets. Simultaneously, we have financial interests amongst countries that are diversified, and we have to work within the scope of soft law as mentioned here because the implementation it's more and more unbalanced. Now, although I admit that many times I'm confused regarding the less lack of act of Brazil regarding the enforcement of treatments, even if the theology used on all this, there's a reason for all this. I am obliged to recognize, although it might seem coherent, it's not, because simultaneously we have TVU rules for developed countries, we have tax parity for developing countries. But what's the reason of being current? It's to avoid double taxation. Both scenarios, Brazil has a stand coherent of defending public funds and treasury. So tax rules during the last time. So what is lacking here? And that's why I would like to wrap up our panel saying that we must have, it must be clear for countries that in this world we are living now, investment, it's very important. And investment is pegged to the legal safety scenario of rules enforcement. I advise companies, I see it's more important to be safe regarding the enforced rule than the taxation per se. And this taxation might can be obtained in a transparent or fair way through these investments that are obtained. And it's very important that these challenges of international taxation in order to generate a development scenario with this improve the world scenario as a whole is that why we need events like this one where smart people present smart solutions. I would like to thank the important solutions you all presented. Once again, thank IBDT and wish you a very pleasant evening.